So when you're summoned, where does it start? I mean, the court process.
Yeah.
What do you do?
The summons will indicate the when you are to attend court and where. And sometimes with the summons is what's called a preliminary brief, which details what the police allegations are. And then you go to court on the day of the first hearing. Most people elect to plead guilty.
Rob, can I ask you a question? Preliminary brief. How do we get that? Does it send automatically, or do we have to?
It is now sent automatically with the summons.
And what's the importance of the preliminary brief?
It has a summary of the allegation, what the police say occurred, how you're intercepted, what your reading was at that time, what comments or explanation that you gave to the police in terms of why you consumed alcohol and drove. So it contains the bare bones of the police prosecution case against you, and it will also have a list of any previous convictions that you may have. So all the information that you would normally require is contained within that brief, and then you would normally get legal advice.
So is there anything more that you need to do? Or you just mentioned legal advice. I had the question of legal advice, and more than anything more than the preliminary brief and legal advice. Anything from the police? Any other evidences?
Answer that, I think.
What you would do is when you get your legal advice, depending on whether your advice is to plead guilty or not guilty, if you take the next stage and plead not guilty, and they're very difficult cases to win .05 cases, but if you take that decision to actually plead not guilty, then you would go to the next stage and get the more detailed brief, which will have where you might be able to obtain a copy of the data download for the preliminary breath test that's been undertaken on you. You might be able to check out the blood samples if you've had blood taken, what the evidence of the police might be, and it's more important, I suppose, in respect to people that are charged with refusing a breath test, that it comes down to the police officer's word against their word as to whether they did refuse and what were the words used by the police officer. So you would look into more detail to get more evidence from the police to then make a final analysis and decision to give to the client as to whether they should be pleading not guilty or not.
That's an interesting thing. If you refuse, compare the circumstances and the severity.
Well, I was going to say it'd be very rare, for instance, on a refuse breath test, and Tim will talk about the defences because that's his area of expertise. But it's very rare, for instance, when you look at the consequences of a refuse, where it's mandatory 2-year cancellation of your licence.
For a refusal.
4 years if you've got any previous conviction for drink driving. It would be very hard for a person to have a reading of 0.24, which would correlate with the period in which you would lose your licence. So before any person refuses, they need to think very carefully. The consequences for just loss of licence, even for a first offender, is 2 years cancellation, and then 4 years if you've got a previous matter. But I think Tim was alluding to if a person's going to contest that, if the protocol and the procedures haven't been properly followed, then a full brief would be prepared, and Tim would bring to bear all his expertise in defending the person, and sometimes police do make mistakes, and sometimes the proper protocols and procedures haven't been followed, and dare I say it, there are other instances where people are wrongly identified, for instance.
Shane, what's the difference between getting a blood test and a breath test? Does that happen or have to happen, both?
Well, essentially what happens is when you're pulled over from, let's say, a booze bus or something like that, you get a breath test. So, one of those straws, you blow into it. And then if they detect a presence of alcohol, what they will do is they will then take you to a bus, a police bus, or maybe even the police station themselves, depending on where's closest, and then conduct a secondary test.
Is that compulsory?
Well, it's compulsory. However, if you do refuse, and this is where the defence, which Tim will come and have a chat to you about, there is some elements where if the police, for example, mislead you or say something which encourages you to not take the blood test, where there can be defences. So no, you don't have to take a blood test, but there are severe consequences if you don't take a blood test.
Well, what happens, Dinesh, is the example that Chen was just giving is that if a person goes back to the police station, they're required to undertake what's called an evidentiary breath test. So there's 3 stages to get to a blood test. The first one is you're put on the side of the road and you blow into the preliminary breath test to see whether you've got alcohol in your blood. in your breath. You're then taken to the police station or the booze bus, and you're then given an evidentiary breath test. There's no obligation on the police to actually take a blood test from you, but if you request a blood test, almost immediately after being given your final reading for the evidentiary breath test.
I just cut you short. Is it worthwhile to have or request a blood test?
Well, perhaps if, for instance, you're on other medication, or if you're asthmatic and you can't blow into the instrument properly or sufficiently. So having a blood test in those circumstances, again, I don't think it's that common, Tim, for a blood test to occur, but
No.
I think where there's health issues particularly, a person might say, well, look, I'd prefer a blood test.
And with a blood test, what Chen's alluding to is the defence that's available, where if you make a request for the blood test, the police have an obligation under the Road Safety Act to take all reasonable measures to ensure you have a blood test. Now, the case that was heard back in about 2003 is DPP versus Moore, where what happened was, in essence, the police talked the gentleman out of having a blood test. He decided not to have a blood test. So as a result of that, the driver was lost the opportunity to test whether the breath test that he'd undertaken earlier was correct or not, because the best way to test it is to compare your blood. If your blood test came up with no alcohol and the breath test came up as having alcohol in your breath, then it's clearly incorrect, because your blood test is going to be the more accurate reading.
Right. We are running out of time, and let's conclude. Tim, what is your message to our viewers in these instances?
Don't drink drive is a good start.
Of course.
It's probably the best advice. But if you do find yourself that you've had too much to drink, or a couple more drinks than you intended to have, and you find yourself in this situation, obviously seek legal advice at the first available opportunity.
Rob?
Yeah, I think to get advice is important. It doesn't mean that you have to be represented at court, and everybody's financial circumstances are different, but as a starting point, I think people ought to get advice, whether it's from a private lawyer, from a community legal centre, or any other legal body, law institute. They all provide various services. I think they should avail themselves of that service.
Chen?
I think the message to take away is the severity of the punishment that could result from drink driving. It's a very serious offence in Victoria, it needs to be taken into account before you decide to have a drink before you drive the vehicle.
Thank you. For more information and catch up on our past episodes, you can go to our website www.lawhelpaustralia.org, or you can visit us on our YouTube channel. Thank you.